Hi, this is day 2 of week 2 of 52 weeks of vlogging, and today we're going to talk about intellectual property rights. I was actually going to talk about something else today, but then John Green posted his video on the Vlogbrothers channel, which is linked down there, and I thought I would respond to that. There were a lot of questions in the comments about, well, could I make a play of your book? Could I make a YouTube series of your book? Could Hank make a YouTube series of your book? And I am not John Green, and I'm not a lawyer. I am not an expert. You shouldn't take any of this as expert advice or advice at all. You should definitely, if you're considering this, consult someone who is a professional. But I do know some things about it since I do write and I pay attention to that kind of stuff. So let's pretend that I am Malinda Lo, who wrote this book called Ash, and it's published by Little Brown. So long ago, I wrote the book. I have my manuscript here. It's a very thin manuscript. I have very tiny writing. And I go through the laborious process of finding a publisher. Yeah, they offer me a contract. And so there are several elements in the contract. One of those elements is the publication of the book itself. They'll probably ask me for world rights, or I could just grant them North American rights or English rights. There's a whole myriad of different spheres in which they could ask for the rights to publish the book. And what I'm doing when I give them rights to publish the book, let's say, just for the sake of argument, that I give them North American rights, that gives them the exclusive right to publish these words in this book in North America. Nobody else gets to do it for a period of time, and it might be a limited number of years, although that's really unusual. It's usually indefinite until either A, people stop buying the book and so they decide it's not worth printing copies anymore, so they take it out of print, or B, they just stop printing it for whatever reason, like maybe, I don't know, maybe they suck. It has been known to happen, although not with this company, for sure. Not Little Brown. Other publishers have sucked and not marketed a book and not really put many copies out there. And there's a clause in the contract that says what those conditions are. And at the point that it reaches those conditions, whatever they are in the contract, and we agree that before anybody signs anything, I get to contact them and say, I want my rights back, and then I can go try to sell the rights to someone else, but they wouldn't get first rights anymore. They would get, that part's complicated. Another part of the contract is audio rights, and this is audio books. So for example, let's pretend that I, Malinda Lo, have sold the rights to publish my book on paper to Little Brown, but in terms of the audio rights, let's say I keep those and I then sell them to another company like, I don't know, Audiobooks R Us, and they buy again the rights to create the audio version of my book for maybe a set number of years, or maybe until they stop being able to sell it, or whatever outlined in the contract. This means that I don't have the right to perform my book anymore. They do. I can't vlog my book. I can't read my book online. I can't read my book in performance spaces. I can read parts of it because that helps sell copies of the book and it's my book, but I couldn't read the entire book because I've licensed the right to do that to somebody else. The same thing basically goes for film rights, which are another part of a contract. So I might give the film rights to the publisher, or I might keep the film rights and then license the film rights to a film company, and that film company may or may not turn my book into a film, but if I've licensed the film rights to them, then I can't license the film rights to any other film company. And also, I can't make any movies of my book. I can't do YouTube adaptations, I can't do TV adaptations, nada, nothing, zippo, blah. Of course, now that I've signed away film rights or audio rights or print rights or all of the above, that means I no longer have them. I can't give permission to anyone else to do those things, just as I can't do them myself, because I've already signed those rights away to other people, and they've given me, hopefully, a considerable amount of money to do so. On the other hand, I can choose to retain those rights. I can choose to self-publish, which means I have all the rights to everything. I can choose to sign away only the print rights to a publisher, and that means that I still have audio rights and film rights, and I can let my brother make YouTube videos out of my book, or let a friend make a play out of my book. I can make a play or YouTube videos out of my book, but in order to do those things or to grant permission to do those things, I have to retain those rights. Now, of course, audio rights and film rights don't necessarily translate into posters, for example, and neither do print rights, because the print rights are just about the words, basically. So it's possible that I could still allow someone to make a poster based on my book, but not allow someone to make a play based on my book. It just depends on what's given and what's retained in the contract that I make with my publisher or the film company or the audiobook company or whomever. So I hope that clears up a few questions. Obviously, it's a way more complicated issue than that. Contracts and contract negotiation are way more complex than I have time for in a short video like this. But at least that gives people some sense of the complexities of being able to make a book into a movie or a play or whatever. That's it from me. Thanks for watching. I'll see you tomorrow.